In the last video, we covered express warranties. Warranties that are created by the party's express words or by the party's conduct through a description, sample, or model of the goods. In this video, we'll look at the first of two implied warranties. Implied warranties meaning they're implied by law, specifically by statute, UCC Article 2. Unlike express warranties, these warranties do not depend on the party's words or conduct for their existence. Instead, these warranties apply when certain preset legal conditions are met. They apply unless properly disclaimed, a topic that we'll take up in a later module. One way to think about implied warranties is as a type of gap filler or default rule. We will discuss gap fillers in more depth in next week's module. But for now, you can think of implied warranties as a kind of default term that is included in the party's contract unless the parties agree otherwise. Thus, implied warranties supplement the parties' agreement that serves as the basis for their contract. Stated differently, implied warranties are a part of the total legal obligations that bind the parties in a contract for the sale of goods. There are two implied warranties under UCC Article 2, merchantability, which we will cover in the remainder of this video, and fitness for a particular purpose, which we will cover in the next. And for each of these implied warranties, we'll try to answer two questions. First, under what circumstances is this warranty implied into a contract? And second, when implied, what is being warranted exactly? So let's start with merchantability. The implied warranty of merchantability is codified in UCC Article 2, Section 314. That section provides that unless excluded or modified, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to goods of that kind. So we need to answer two questions. Under what circumstances is this warranty implied, and when implied, what is being warranted? As to the first question, under what circumstances is this warranty implied, the answer here is straightforward. It's implied whenever the seller is a merchant with respect to goods of that kind. So unless properly disclaimed, something that we'll discuss in a later module, every contract where the seller is a merchant of goods of the kind being sold, the seller makes an implied warranty, implied by law, that the goods sold under that contract are merchantable. Non-merchant sellers do not make an implied warranty of merchantability. Note, though, that a non-merchant seller could still make the equivalent express warranty by stating it. The difference is that's an express warranty, not something that is implied by law. Likewise, there is no implied warranty of merchantability even when a seller is a merchant, but not a merchant with respect to goods of that kind. So the critical question here is, what is a merchant with respect to goods of that kind? To answer this question, we have to become a bit more sophisticated in our understanding of the term merchant. Recall the definition of merchant from Article 2, Section 104. That definition provides that a merchant means a person who deals in goods of the kind or otherwise by his occupation holds himself out as having knowledge or skill peculiar to the practices or goods involved in the transaction. This definition suggests that there are three different categories of merchants. One category would be merchants who deal in the goods of the kind being transacted in. A second category would be a seller who by occupation holds herself out as having knowledge or skill peculiar to the practices involved in the transaction. And the final category would be a seller who by occupation holds herself out as having knowledge or skill peculiar to the goods involved in the transaction. We can group these three categories of merchants into two distinct groups. One group we might call practices merchants, sellers whose merchant status derives from their familiarity with business practices involved in commercial transactions, practices including the negotiation, drafting, and performance of commercial transactions, especially transactions involving the sale of goods. This category is quite broad. Anyone who is regularly involved in the business world could qualify as a practices merchant. Indeed, recall comment 2 to this definition that we viewed in a previous video. Almost every person in business would, therefore, be deemed to be a merchant under the language who by his occupation holds himself out as having knowledge or skill peculiar to the practices involved in the transaction, since the practices involved in the transaction are non-specialized business practices. The other two categories of merchants we might group together and call them goods merchants. Their merchant status derives from the party's familiarity with the particular type of goods involved in the transaction. It is these kinds of merchants, goods merchants, that Section 314 is referring to when it says a merchant with respect to goods of that kind. And therefore, it is only these kinds of merchants, goods merchants, that are subject to the implied warranty of merchantability. So now we know under what circumstances the implied warranty of merchantability is implied. That leaves us with a second question: what does it mean to warrant merchantability? When merchantability is applicable, what is being warranted exactly? Subsection 2 of 314 provides a list of 6 non-exclusive criteria for determining the meaning of merchantability. Criteria including things like the goods must pass without objection in the trade. The goods must be of fair average quality in the case of fungible goods. By far the most important criteria is in subsection C, which provides the goods must be fit for the ordinary purposes, uses, or functions for which such goods are used. Stated more broadly, the goods must be of a generally acceptable commercial quality, that is, good enough to satisfy the reasonable expectations of the average ordinary buyer. The reasonable expectations about how such goods will perform when they are put to their ordinary use, purpose, or function. This definition reflects the tort origins of the implied warranty, arising from products liability law and the tort standards for negligence. Goods must satisfy the reasonable expectations of the average ordinary buyer. So what qualifies as merchantable goods will vary based on the type of goods involved. For example, the applicable standards for merchantable blueberries are very different than the applicable standards for a merchantable bike. Likewise, the applicable standard for merchantability of used goods will be very different than the applicable standards of merchantability for new goods. That's right, nothing in the statute limits the implied warranty of merchantability to new goods only. Used goods, for example, a used car, clothing, or smartphone, are all also subject to an implied warranty of merchantability. But the standard of merchantability will be very different for used goods. That's because the reasonable expectations of an average ordinary buyer with respect to used goods will necessarily be lower or less than new goods. The expectation depends on the exact nature of the goods, how used, in what condition, and what the price is being paid. Indeed, comment 3 to 314 acknowledges this fact, stating that the warranty applies to second-hand goods or used goods, but the warranty implies only such obligation as is appropriate under the circumstances. So the buyer of used goods gets less protection under the implied warranty of merchantability, but remember, parties are always free to bargain for additional protections in their contract. So if a buyer of second-hand goods, or even of new goods for that matter, wants more protection than the minimal protections afforded by the implied warranty of merchantability, the buyer can bargain for an express warranty in the party's contract about the quality or nature of the goods that goes above and beyond the implied warranty of merchantability. So in this video, we covered the implied warranty of merchantability, focusing on when the warranty is implied into a contract for the sale of goods, and when implied, what the warranty requires. In the next video, we'll take up the same two questions in the context of the other principal warranty implied by Article 2, the implied warranty of fitness for a particular purpose.